If the 1973 Roe v. Wade decision were reversed, the effect on the number of abortions in the United States would be, according to many experts, a reduction of only 10 or 15%. The most interesting thing about Roe v. Wade, therefore, is not the extent to which it keeps abortion accessible, but rather the fact that it's bad law that usurps the rights of states. And bad law that restricts rights is what it's all about when you come to take the gold pill. The two major parties in the media can no longer be expected to represent our interests. They control the information we receive in order to keep us comfortable with their profits and with their power. Comfort is not what I offer, only the truth, nothing more. The reason that a reversal of the Roe decision would have only modest effects on abortion numbers is that most states wouldn't change their laws at all, already having mostly pro-choice constituents. In the states that would impose greater restrictions, those restrictions would not mostly be total bans, but would merely make services either less accessible geographically, limit the time or circumstances under which they would be legally accessible, or require certain disclosures, either to the mother or to other parties. This is not to argue in the face of pro-life advocates that any reduction in the numbers would be unimportant. They would be important. But it does suggest that those of us who would like to see the number of abortions come down will have to bark up some very different trees to find the most meaningful answers, Roe or no Roe. It also suggests that the passion that has infused the debate over Roe the last 48 years probably exceeds what it would be if everyone were to come to terms with the limits of the effects of the decision today. And that passion has been responsible for so many restrictions on our political debates. Just think how few pro-choice Republican politicians or how few pro-life Democratic politicians there are. Were matters of abortion regulation left to individual state legislatures, or perhaps even to state courts, or even to state constitutions, the national parties would better be able to assume more nuanced positions in the debate and would therefore be less polarized on the matter of loyalty to a party's position on abortion. Opinions in the United States remain mixed regarding the ethics and the constitutionality of abortion and under what circumstances it should be legal. Opinions continue to be correlated with geographic regions as well as demographic characteristics. Though nuance doesn't always get revealed politically, opinions can be fairly nuanced when you speak with individuals. This is also true among libertarians. Most libertarians are pro-choice, though a significant and passionate minority are pro-life. But even among those that are pro-choice, there is a recognition of just how problematic the Roe decision was. And the problem in Roe that many experts recognize as important is actually huge when viewed through the lens of libertarianism. The problem is that the court, whose job it is to enforce the Constitution, made a decision that was not allowed by the Constitution. The court is not allowed to strike down laws that do not violate the Constitution, and when it does, it takes away from legislatures the right to make decisions that are most appropriately made through the political process. Let's look at the constitutional problem with Roe from two different angles. First, the assertion of a right to privacy, which is the basis for the decision, is not nearly as easy to appreciate as would have been an assertion of a right to liberty. And yes, I do believe the difference in language matters in this case. If you believe that a fetus is a life with rights worthy of protection by the state, asserting that the privacy of the person who wants to end that life must also be protected isn't a very compelling argument. On the other hand, if you assert that the person making the decision has liberties that the state cannot infringe, then at least now you're having an argument about balancing competing liberties. The decision in Roe v. Wade says it prefers using the 14th Amendment over the 9th Amendment and goes on to spell out why a woman has an interest in making a decision to have an abortion. Personally, I never find a court decision that claims to balance different people's interests, especially when one of those persons has his or her life on the line, as compelling as what I would call the none ya argument, as in none ya business, as in the heart and soul of the 9th Amendment. The second way to look at the constitutional problem in the Roe decision is to look at an important passage in the decision itself, which, read plainly, seems to indicate that the justices themselves did not really believe with conviction that they should be making this decision. Regarding the matter of when an unborn fetus becomes a living being, the majority opinion said, and I quote, "When those trained in the respective disciplines of medicine, philosophy, and theology are unable to arrive at any consensus, the judiciary, in this point in the development of man's knowledge, is not in a position to speculate as to the answer." Agreed. But the decision went on to rule that because a fetus became viable under current medical technology at the beginning of the 3rd trimester, the state could, at that point, legally prohibit abortion. But the decision just said you could not weigh in on the matter of life. If you can't weigh in on the matter of life, how do you weigh in on whether viability is the critical determinant of when life is worth protecting by the state? And to be clear, the court said the right to privacy was not absolute, but rather it had to be balanced with government interests, including an interest in protecting the life of the fetus. The court struck down Texas's abortion law in this case, which had been based on the belief that life began at conception, for being unconstitutional because it did not regard the stage of pregnancy and did not recognize the other interests involved. So, yes, the court in the Roe decision did weigh in on when life begins. And it's not, according to the court, at the point of conception, apparently no matter what Texas says. In addition to the legacy of political suppression left in the wake of Roe, the decision seems to have set up some newfangled form of stare decisis. In the 1992 Planned Parenthood v. Casey decision, the court said that it would not overturn Roe. Here's why. The decision written by the controlling plurality said that society had developed for nearly 20 years in a way that was affected by the Roe decision. Women's lives had become better since and because of Roe. And therefore, and I quote, "A decision to overrule Roe's essential holding under the existing circumstances would address error, if error there was, at the cost of both profound and unnecessary damage to the court's legitimacy." In effect, the court was admitting that the reason for upholding Roe and thereby denying states' rights was not because of constitutional principles, but because the justices liked the result that came from Roe and didn't like being made to look mercurial. The decision in Planned Parenthood v. Casey went on to say that the justices would not change their minds just because their decision had been unpopular with some people. By contrast, the justices wrote in the Casey decision that the reason that they could justify a reversal of Plessy v. Ferguson in the Brown versus Board of Education case decades earlier was that society had changed in a way that rejected the earlier separate but equal doctrine in that case. So to summarize, the Supreme Court believes that its own public image is so important that it should not reverse its decisions in order to align with constitutional principles, unless society has changed in a way that diminishes the popularity of the earlier ruling. This is not merely the definition of judicial activism. It is what might be called populist judicial activism, the worst kind. On some level, you have to admire the chutzpah of governmental institutions, like both the Supreme Court and more recently the CDC, that operate independently of elected authority and admit such bald-faced political maneuvering. Whether you like the immediate result of recent judicial activism or not, whether you're pro-life or pro-choice, such brazen institutional power grabs are so out of line with our constitutional protection of states' rights that they must be stopped. This won't be easy. Politics has become a battleground. On one side of this battle are politicians and pundits, journalists and jurists, regulators and revisionists, who believe the government is better able to solve our problems than we are ourselves. On the other side of this battle are things like science, history, people like you, people like me, and common sense. Thanks for helping me make this sense a little bit more common. Thanks for coming to take the gold pill. Comfort is not what I offer, only the truth, nothing more.